Bom dia a todos, novamente. Eu gostaria de começar esse painel com um agradecimento. Com um agradecimento. O nosso seminário tem ficado cada vez mais internacional. E não só isso é fruto da participação do IBRAC em vários eventos, em comunhão, talvez, com outros institutos internacionais, mas também uma das grandes razões é podermos contar com palestrantes internacionais e pessoas tão importantes no nosso meio antitruste, nos nossos eventos. Por isso, nós começamos com o nosso agradecimento pela presença de vocês aqui, né, que abrilhantam e trazem os temas principais, as discussões de outras jurisdições, para que nós todos possamos conhecer aqui no Brasil. A ideia nossa nesse painel é fazer perguntas, a ideia é ser um bate-papo com os palestrantes e não termos um tema só, mas o que nós imaginamos é poder abordar diferentes aspectos e diversos temas, em especial relacionados aos currículos e à experiência de cada um dos que aqui compõem o nosso painel. Por essa razão, eu, o Ribas e o Léo preparamos algumas perguntas de acordo com os currículos e com a experiência desses palestrantes e vamos endereçar cada uma dessas perguntas. A nossa ideia a gente vai, durante algum tempo, talvez uma hora, endereçar essas perguntas e depois a gente vai abrir para que vocês também possam fazer perguntas a cada um deles. Bom, eu vou começar, então, com a minha primeira pergunta, e relacionada a um pouco à experiência do TON internacional em transações internacionais que são notificadas muitas vezes em várias jurisdições. Né? A gente tem ouvido falar um pouco sobre alguma discussão sobre um eventual protecionismo europeu em relação às transações que são notificadas na Europa envolvendo empresas europeias e também ouvindo a mesma coisa em relação a transações notificadas nos Estados Unidos em relação a empresas americanas. E a gente queria um pouco ouvir, a gente sabe que você tem muita experiência em notificação e discussões de transações notificadas em várias jurisdições, e a gente queria um pouco ouvir se você concorda com essa ideia e qual a sua experiência.
Well, thank you, Leonor, for the question. I think from a European perspective, I think I would disagree with the contention that there is some sort of protectionism has crept into the European Commission's review of mergers. I think in relation to merger control, I'm not sure whether there's sort of a debate that U.S. companies or foreign companies more general are being treated more severely than the European counterparts who file their mergers for review by the European Commission. I think there are a number of sort of hotly debated mergers which I think have been discussed in the context of the conference as well. For example, Dow-DuPont, that's a case which involved exclusively American companies, but I don't think that the nationality of the companies as such had any impact on the way in which the Commission reviewed that case. I think that case was about sort of the innovation theory of harm, which is sort of a theory which the Commission has been focusing on for a number of years. But again, I don't think that the nationality of the companies as such had any impact or influence on the way in which the Commission looked at that case. And I would actually turn it around in the sense that sort of having acted for a number of European companies in the context of merger control cases, it is very difficult to bring an argument to the Commission on the basis of sort of creating a European champion. I think a number of private practitioners in Europe would probably think that there is some room for improvement at that level, that the Commission takes into account some sort of broader industrial policy arguments in its review of mergers in order for European companies to become more competitive on the global field. So, in relation to merger control, my short answer is no. I don't think that there is any problem of protectionism in Europe.
Posso só completar a minha pergunta? Se você pudesse falar, antes de passar para o Léo, em relação a condutas. A sua opinião é a mesma?
Well, in relation to conduct cases, I think I am of the same opinion. There are probably sort of a number of aspects to that view. I think in relation to cartels, I'm not quite sure that there are any statistics out there which suggest that American companies have been treated more severely than European companies. I think I was involved in a study about 2 years ago, sort of looking at the nationality of the prime targets of European Commission cartel investigations, and I think what came out of that sort of statistical analysis is that it is actually Asian companies who have been the prime target of cartel investigations, not only in Europe but also in the US. So I'm not seeing any sort of level of protectionism at the level of cartel enforcement. I think unilateral behavior, that others may have different views, but I think, again, the cases which we are seeing at the European level, the cases like Intel, Google, are obviously cases which are very high profile and being hotly debated in the antitrust arena. But I think, as Professor Wish already indicated the day before yesterday, if you look back at the track record of the European Commission in terms of enforcement unilateral behavior, the vast majority of the cases have been targeted at sort of breaking up monopolies in the European member states, and I don't see any reason to argue that there is protectionism from the Commission side. So I think maybe one final remark, and that sort of completes the picture. I think a number of those comments about protectionism have also been made in the area of state aid in Europe, which is sort of a fundamentally European part of competition law. The Commission has been investigating a number of member states recently for granting selective tax benefits to a number of multinationals. Again, very high-profile cases which have been reported on widely in the mainstream press. Cases involving companies like McDonald's, like Amazon, Apple, Starbucks. Again, I do not see any sort of link between the nationality of the companies involved in those cases and the way in which the Commission analyzed the behavior of the member states, because those are investigations against member states and not individual companies. I think had those companies been European companies, the outcome would have been exactly the same. And I think the practice also shows that there were a number of those cases which were targeted against member states having granted selected tax benefits to European companies. So I just don't see any protectionism in European competition law.
Obrigada. Só fazendo duas observações que eu esqueci aqui. No início, o meu chefe à esquerda está me pedindo para avisar que o check-out do hotel é até 2 horas, então todo mundo pode esperar, tá? Segundo lugar, a Fiona vai fazer interrupções e Fiona sinta-se livre para fazer comentários a qualquer uma das perguntas. Léo?
Eu tenho uma pergunta para o Paul. A gente sabe que o Paul tem uma grande experiência nas ações privadas de indenização por cartel, e a gente está nesse momento aí de definir a resolução do CAD. Queria algumas sugestões do Paul em relação a como estabelecer um equilíbrio adequado entre a proteção dos dados que são apresentados às autoridades e, inclusive, a proteção do próprio programa de leniência e o adequado incentivo às ações de reparação de danos. Como o Paul poderia nos ajudar com informações e com a sua experiência para estabelecermos esse equilíbrio adequado?
Thank you very much. So starting on the question of leniency statements, I think the first comment I would make, and this is a general comment, is that these tasks of looking at evidence and seeing what should be produced are tasks which are perhaps best carried out by the courts, who are used to dealing with evidentiary issues. Confessions in criminal processes, I believe, are not so strange to be produced in civil proceedings. So it's a bit of a particularity of the competition field that we have so much concern with what the courts are going to do, but there may be good reasons for that. But as a first answer, I would say that the right balance can be struck by the courts themselves. That was indeed the position that was adopted in the European Union originally by the European Court of Justice in the case of Flyderer, and that was then employed, that criteria, which is essentially the judge in the case, the civil case, should strike the balance between what was really necessary for the civil proceedings to protect the right to claim damages, and at the same time protecting the public policy goal of incentivizing leniency and therefore protecting public enforcement. And we have a good example of the balance being executed, let's say, by Peter Roth, the judge of the Competition Appeal Tribunal in London, in the case of National Grid, and that was an interesting exercise. It has to be said that there aren't very many judges as good as Peter Roth, and there aren't very many places where you can spend quite so much time over it, and it was a very, very time-intensive exercise. So one can then appreciate why, perhaps in a rather paternalistic way, the European Union then legislated the question and said, no, we're going to decide this. Leniency statements can't be produced, nor can settlement submissions. So the decision was taken out of the hands of the judge. There's still proportionality with regard to other issues. I would then add that as a practitioner looking at these cases, leniency statements I don't think are so important as perhaps you might think. The key for anyone looking to bring a claim is the decision, and then depending on the disclosure regimes that operate, the pre-existing documents, and those will be subject to normal disclosure rules. Confidentiality, of course, is something that's carried out within the proceeding of the administration, and it's a useful first exercise, let's say, but I would also add again that the court will have its own criteria for deciding what should be protected as confidential in a civil proceeding. Worth noting on decisions, that for me is the key, and the question is how much information do you put in the decision? As was mentioned earlier, Bill mentioned this in his intervention, in some of the older commission decisions, there was a lot of detail, and some of that is extremely useful and interesting for people looking to bring claims. One of the problems of having such detailed decisions is that it can take enormously long to actually publish them because of all the fights about confidentiality, and air cargo is a good case in point where there's years trying to get the final judgment decision published, and that's one of the reasons maybe that shorter decisions end up being published, and that there can be a balance to be struck there. Final point on incentivizing, again, I underline the importance. This is not a practice that's carried out in the administrations. It's a practice that is carried out and enforced by the courts. The courts are the ones that have to deal with all these issues. The key is having good courts. I know that there's a decision being adopted, I think, in Brazil to create a competition court, which I believe could deal not only with administrative cases, but civil, specialized court. That, for me, is the key incentivizing tool, is to try to get good courts that can manage these cases.
Obrigado. Ribas.
Uma pergunta para o professor Wish. Na sua apresentação na última quarta-feira, o senhor nos trouxe análise sobre o caso Intel e a jurisprudência de descontos na União Europeia. E foi muito interessante ouvir como a interação entre as cortes europeias e a Comissão Europeia foi enriquecedora para esse debate, para a construção da jurisprudência. O senhor também explicou as diferenças dos sistemas jurídicos na Europa e nos Estados Unidos e das instituições nessas regiões que podem explicar as diferenças de resultados em casos como Intel e Microsoft. Então, a nossa pergunta é, num hot topic para os ingleses, como fica o Reino Unido após a saída da União Europeia. As cortes inglesas terão o mesmo nível de interação com a Competition and Markets Authority na Inglaterra, e a gente pode esperar uma mudança da Inglaterra mais semelhante ao modelo americano, tendo em vista que Os dois são países de common law?
Well, I can't say what's going to happen after Brexit because it's obvious that our government doesn't know what's going to happen after Brexit. It's getting very close. It's about 16 months away, and the government hasn't even begun to disclose what the future shape of things might be. Brexit has enormous implications for the United Kingdom, but I don't think it has that many implications specifically for competition law, and I'll explain why. After the referendum, a small group of us came together and established the Brexit Competition Law Working Group, 7 of us, and we submitted proposals to government in July of this year, and they're available on the web, and we looked very carefully at what Brexit would mean for the domestic competition law of the United Kingdom. And broadly speaking, I don't think there's a problem, actually. And the reason for that is that we have a domestic form of Articles 101 and 102. We've got a very well-established merger control system. When we leave the EU, the domestic law is all in place. So there's no immediate amendment that's needed, there's no gap. So from that point of view, it's quite a seamless process. Obviously, there are formidable issues over transitional matters. What about a merger that has been notified to the European Commission pre-Brexit, where the decision is going to be post-Brexit? So there are technical transitional issues of that nature. It'll also be important to put in place international cooperation mechanisms, because at the moment, of course, the United Kingdom is part of the European Competition Network. The Competition and Markets Authority works very closely with DG Comp in Brussels, with the Bundeskartellamt in Germany, and so on and so forth. But all the machinery that enables that cooperation to take place to get today will go. So it'll be very important to put something in its place. I think you're asking a broader question. Might UK law diverge from EU law over time? And if it diverges away from EU law, will it converge towards the American system? Well, I don't see that myself. The words of our legislation are the same as the words of Articles 101 and 102. And, you know, a cartel is a cartel is a cartel. And there's no reason, I think, for the United Kingdom to establish different standards for controlling cartel behaviour. Conceivably, the UK might want to diverge from some aspects of EU policy. In particular, as many of the people in the audience will know, one of the overarching goals of EU competition law is to create a single market. Well, after Brexit, we will be outside that single market. So whether that single market imperative will continue to influence our domestic law, I just simply do not know. I've already spoken about EU, US. I think a lot of the discussion around that topic is oversimplistic. I don't see any inevitability about our converging on US law. What I would say is, post-Brexit, we will have the ability, if we so wish, to develop our own competition policy, taking into account international practice.
Bom, a minha próxima pergunta para o Michael. A gente viu que pelo seu currículo que você tem bastante experiência em casos de sham litigation. E esse é um tema que nós importamos dos Estados Unidos e que para nós ainda é um tema frequente na jurisprudência, nas discussões, mas a gente não tem visto muito as decisões, não mais, nos Estados Unidos, o que nos dá um pouco a impressão de que talvez seja um tema já antigo nos Estados Unidos. A gente queria saber se você concorda com essa opinião e qual é a sua experiência em relação a esse tema de sham litigation.
Thank you. So I would say you're correct that sham litigation is not at the tip of every U.S. Antitrust lawyer's tongue, and the jurisprudence is not rapidly evolving. We kind of have the standards, which are not exactly uniform across the various circuit courts. So it is somewhat static at this point, and we have other issues that dominate, our litigation dockets, such as foreign commerce issues. What commerce counts under the Sherman Act, and that's where we spend a lot of our time litigating. The way I think of sham litigation is typically you're going to see that in the context of someone brings a patent infringement claim, and if you're the defendant in that patent infringement situation, you have a variety of tools in your toolbox to fight back at the patentee who's suing you. One of those is a sham infringement claim. You can also assert claims of, a Walker process claim of fraud on the patent office. But I think one of the reasons why we hear a little bit less about sham litigation, the essence of that being really, as a defendant, you're saying, I think that the suit you brought is objectively baseless, and the reason you brought this was to try and interfere with my business. A much more effective and recently developed tool for a defendant in a patent infringement case is the inter partes review process, the IPR process, which now is a very quick and efficient way to get in front of the patent board in the United States, to have them take a very quick look at the patent, and if it really is a bunk patent, if it really is based on prior art, if it's no good, that's really the most efficient vehicle to strike back at someone who you think is bringing a baseless patent infringement case against you. So I think that's one of the main reasons why you haven't heard so much about sham litigation, is this IPR process.
Obrigado, Mike. Mais uma questão para o professor Bill. A gente viu essa excelente exposição do professor Bill agora pela manhã, e a gente vê também pelos artigos que ele publicou recentemente um olhar muito cuidadoso sobre a atuação de várias autoridades da concorrência e uma sugestão, talvez, de um foco maior dessas autoridades em buscar menos os casos chamados high profiles, mas muito de construir uma infraestrutura necessária para que a autoridade tenha condição de cuidar dos casos mais relevantes. Então, eu queria aproveitar um pouco da experiência do professor Bill para dividir conosco o que, de fato, nesse momento ele entende como infraestrutura necessária que uma autoridade como o CAD, por exemplo, precisa ter para enfrentar um momento difícil como esse que nós vivemos.
One of the hardest issues is to deal with the relationships with other institutions that have figured so prominently in the discussion this week. Whether it's the central bank in dealing with merger control or other forms of competition-related behavior, whether it's the relationship with public prosecutor, anti-corruption authorities whose work, of course, is deeply involved in the exercise of the cartel enforcement mandate. All of these relationships can be seen as the equivalent of building bridges and establishing a mechanism for traveling across them on a regular basis. These are infrastructure investments in institutional arrangements. They don't have immediate payoffs. They tend to be long-term capital outlays, but without them, you can't make the exercise of concurrent, shared, parallel authority effective. So I would say, and I think Kajay understands this with great clarity. It's why you have the formation of the working group with the central bank. It's why you have the ongoing efforts to develop a better understanding with prosecutors, among other topics, on the significance of individual, unilateral, uncoordinated decision-making on the operation of leniency and other mechanisms. So one continued investment that I think the community would applaud is a dedicated effort to continue to invest in building these relationships, really at three levels. It starts with a top-level commitment by agency leadership, and on Monday in Brasília, in the program at the central bank, we saw the president of the central bank and the president of CAGE dedicate themselves once again in a very public way to this kind of collaboration. That sends a powerful, constructive signal to the rest of the institution. But the same form of collaboration has to take place at the level of senior management, project management level, and at the level of case handlers. So a continued dedicated effort to make this investment in building relationships, I think, is a wise path. A dilemma is that it doesn't show up on the scoreboard in any visible way. That is, how are agencies measured? That would be fines, cases, fines, cases, cases. If you give a talk to an audience, I found when I was in an agency and saying, this is what we're going to do, the audience looks through the program to see if there's a parallel session they can attend. And they turn back to those little evil devices and start looking at them. Once you talk about institution building, you've lost them right away. Yet, if you think of the areas of relationship with the banking institutions, the development of the ever more effective cartel enforcement program, the application of criminal authority, I don't see how that can happen if the bar in the larger community does not applaud that continued investment. Another that comes to mind is the ever important question of human capital at the agencies. If you ask what's a good agency, I'd say, tell me who's playing. Let me look at the team. Don't tell me the total number of employees. Tell me the total number of good employees, really good ones. That's the head count I want to know. Brazil's had a lot of success in drawing good people in, but I'm struck at how many of the junior people I see in law firms who would like to have an opportunity to have that experience would not readily have a path to do that. I'm a fan of the revolving door. I realize it's, again, a matter of dosage. It can spin too fast. But I think it would be enriching for CAGE and for the bar if there were more opportunities for junior people to go into the agencies for a while. I couldn't imagine having a senior position in a competition agency if I'd not worked in a law firm as well. I just not a day goes by when I didn't draw on something. So a program that could consciously have that circulation of people into the agency, out of the agency. In some countries, it's done with a conscious view that it's almost like a secondment. You're going to go work there for 2 years. You're going to work for 3 years. You're going to come back. But I think there's an enormous value in the education that takes place, both for the bar, that is, the agency isn't crazy, and for the agency, the companies aren't always devils. The tempering benefit that comes from that relationship, if there were a way to add that to the mix of building human capital, I'd do that too.
Bill, I completely second that, and my experience coming from Europe, where the European Commission was pretty much impenetrable to private practitioners, and largely still is, I think is one of the areas where Europe could actually benefit from a revolving door as well. I remember sessions with case handlers where they would accuse our clients of all sorts of nefarious schemes that they didn't want to disclose to us because they didn't want to educate us on how nefarious we could be. And I thought, look, a couple of days in a company or a law firm might actually teach you that many of us are just trying to make a living here, and we're not sitting there dreaming up plots to cartelize or otherwise destroy Europe. The other thing that occurred to me as I'm sitting here on this panel is the role of the courts in institution building. And again, coming from practice in Europe, where we were largely in a model of judge, jury, and executioner for most of my time there. That was a very different world from then traveling across the pond to the US, where I realized that every aspect of our practice was subject to the rigor of a court. And the agencies know that as well, and every aspect of their investigation is also subject to the overriding discipline of a court. Not employed in most cases, but nevertheless there as a constraint. So I'm very excited to hear about the proposal to form a specialist competition tribunal, a court, in Brazil, because I have seen that be a very effective method for helping agencies evolve to a higher level. Let's just look at the Intel case as an example in Europe, and earlier cases where the CFI knocked the European Commission down for failing to adequately examine the evidence and prove its case. I'm all for courts having a role in the development of our institutions, the competition agencies.
Obrigado. Agora uma pergunta ao Stephen. Falamos bastante aqui sobre diferenças nos Estados Unidos e na Europa, e a gente não poderia deixar de fazer uma pergunta para você, que trabalhou por muitos anos para o Google. Esse ano tivemos a decisão do Google Search na Europa de condenação, em contraste ao arquivamento nos Estados Unidos. O que você pode falar a respeito disso?
Thank you very much. So I think the question of why the case went so differently in the US and Europe is a really interesting question, and I don't think anyone knows the answer. I mean, on the one hand, we have the FTC, which looked at this and came to the view that Google's conduct was essentially good for consumers. And on the other hand, we have the European Commission, who came to the view that there was an antitrust abuse, and they fined Google with the biggest antitrust fine in history, 2.4 billion euros. As I say, I don't think anyone knows the answer, but I think it's useful to consider four sort of possibilities of what might be driving these differences. I think possibility one is that there's some kind of difference in doctrine between the US and Europe. That's possibility one. Possibility two is that the facts of the case are different. Possibility three is that one of them has made a sort of substantive error. So either the European Commission has made a type 1 error or the FTC has made a type 2 error. And possibility four is that there's political factors involved. And these are the kind of four possibilities. So kind of going through these, I think the first one on is there a difference in doctrine? And obviously the FTC, when they made their statement, they made a very clear statement that competition law is, the purpose of it is to protect an effective competitive process, not to protect individual competitors. But I think the European Commission thinks exactly the same thing in practice. I don't think that you can point to any sort of high-level ideological difference as a reason for a divergence here. Second point is the facts of the case. Now, obviously, there's always going to be differences in the facts of the case. One issue to consider is that Bing has got a stronger position in the US than it does in Europe. But having said this, I struggle to see how different facts of the case could give rise to this divergence. The conduct is essentially the same across in both jurisdictions. Possibility three is that one of them has made a substantive error. Now, obviously, I'm an advisor to Google, so I obviously think that the European Commission has made a substantive error. Obviously, Google has appealed, so we'll get to find out in a few years whether the court thinks that the Commission has made a substantive error. So I don't think there's anything more I need to say about that for the moment. And the fourth factor I said was maybe we need to understand something to do with politics around this case. And I think I'll make a few observations here. The first is that I do not think there's an anti-US bias. I think a few people have said that. I don't see any evidence of an anti-US bias. So I don't think when I talk about politics, I don't mean sort of international politics. Another observation I'd make is that regardless of whether you think that the European Commission case team is influenced by politics, I think it's very clear that there is politics around this case. If you think that during this case, the European Parliament discussed breaking up Google. And then just this week, there's been a draft report in the European draft parliamentary report saying that the remedy doesn't go far enough. Right? So I don't know whether the person who drafted that report has read the decision and fully appreciated all the nuances of the competition problem that needs to be fixed here, but that's an interesting, very quick reaction from the court, so the remedy doesn't go far enough. And then I think another observation I'd make is that the case it's unusual, right? So the Commission went down a commitment path. They thought they could resolve this without a fine, and just by saying Google needs to change its conduct. Commissioner Almunia wrote rejection letters to the complainants in this case, and said very publicly, "I don't see how I can that I will change my mind about this." As far as he was concerned, the commitments solved the problem that he'd identified. But then, of course, he did change his mind, and there have been some observers who have pointed to a change in the president of the European Commission around that time. And obviously, I'm not going to make any further comments about that. But so from my perspective, it's now just looking forward to when this is going to be heard in court, and then we'll get to see what the court thinks.
Bom, obrigada. A gente agora queria checar se tem alguma pergunta. Bruno?
Bom dia a todos. Eu queria endereçar a pergunta inicialmente para o Paul e para o Michael, mas, obviamente, abrir para quem quiser comentar em cima disso também. Eu acho que nós estamos aqui no Brasil agora, o Léo mencionou, no momento que alguns da nossa comunidade concorrencial, alguns já perceberam isso, eu acho que outros ainda não. Mas eu acho que nós estamos à margem da terceira revolução do antitrust aqui no Brasil. Pode parecer até muito forte essa afirmação, mas eu gostaria de entender de vocês, quer dizer, olhando de fora, conhecendo da forma que conhecem o país, como é que vocês veem, quer dizer, um bem implementado sistema de private enforcement, de ação de reparação aqui no Brasil? Como é que isso pode mudar o sistema concorrencial brasileiro? Como é que isso pode impactar na questão do enforcement? Para dar dois exemplos, quer dizer, o private enforcement pode liberar recursos de uma autoridade que tem poucos recursos para, inclusive, ir atrás de conduta unilateral. O private enforcement ele pode fazer com que haja mais compliance, quer dizer, para você apontar o dedo, você tem que olhar se você não tem telhado de vidro também, você tem que fazer o seu dever de casa. Então, como é que isso impacta? Como é que essa revolução pode impactar o sistema concorrencial brasileiro, a comunidade concorrencial brasileira, por sua vez? E só um ponto adicional a isso, é a questão, vocês veem que necessariamente tem que haver uma bipolarização, quer dizer, como acontece, acho que muito mais nos Estados Unidos do que na Europa. Você tem escritórios especializados em autores, você tem escritórios especializados na defesa das empresas. Ou pode ser algo que é muito mais difuso, pelo menos nesse primeiro momento.
Thank you. That's a great question. From the American perspective, I would say to one of your first points, absolutely the presence of effective private civil enforcement can do wonders to free up resources for government agencies to focus on criminal actions, for one, in the U.S., and also to focus on their particular priorities. If there are particular industries, if there are particular types of offenses that the agencies want to spend their time on, then having the private enforcement as a backstop is a huge thing to be able to rely on. As you're undertaking this third revolution, there's probably some lessons to be taken from the U.S. system in, do you really want to go the full litigation route that is the American judicial system? I mean, it is fabulous for antitrust enforcement, for antitrust deterrence. Probably estimates are 90% of actual enforcement of the antitrust laws is done privately. So, and it's done with the threat of treble damages, of real deterrent teeth. But, there's probably, just from an outsider's perspective, there's probably a little bit of a middle ground to not go the full route of the U.S. court system where claimants are so incentivized to bring claims, to be able to recover attorney's fees, to seek joint and several liability, to be able to get treble damages. On the point about does there have to be polarity of firms representing either plaintiff's side or defendant's side? I think in the U.S. where that line is most strongly drawn, and it's really a Rubicon that you cannot cross, is with respect to class actions. You really can't be a plaintiff's class action lawyer and then turn around and be a defense class action lawyer. You really have to pick a side on that because you are routinely arguing as to how the class action device should be interpreted, what standards should be applied. In the U.S., there are certainly firms that represent both claimants and defendants, as long as it's not in a class action context. So as long as you're not moving immediately towards a class action world, I think there's definitely room to have specialized firms that can be on either side of civil enforcement.
Thank you. I think the perspective from Europe is somewhat different. On your first question, does it release resources for the competition authorities? I think the answer is definitely, for the moment, no. Why is that? Well, I think perhaps because the civil system of damages doesn't have the same teeth that the US system has. So you don't have broad disclosure in most places, you don't have treble damages, and you don't have, although there's the beginnings of it in the UK now, you don't have class actions. So it means that compensation claims or damages claims are more for compensation by corporate entities normally. So I don't think it's, so there aren't many standalone cases, for example. They're all follow-on cases. So if anything, the work of the competition authorities may be somewhat more because they're having to prepare files more carefully for considering the private enforcement side of things. What has released resources in the EU has been the decentralisation from the Commission to the national competition authorities and their ability to apply European competition law and the provisions of Regulation 1/2003. On your second question, how does it affect the antitrust community? Well, I think it changes a little bit the profile in some ways because litigators begin to become involved. You see new lawyers getting involved in the field. You see the need for collaboration from an early period, an early moment between competition lawyers and litigators. So already during the public investigation, preparing for what was going to come in the future, and that would be influencing decisions, for example, on leniency, etc. And you see new law firms appearing on the horizon. And on your last question about bipolarity, well, I think it's the reality in Europe is you don't have such a dichotomy, except in some of the major law firms who are involved in so many of the high-profile cases that it makes sense for them to choose to be on one side or the other. If not, one would tend to apply normal conflict rules and normal business, let's say, of your litigation department. So, for example, in Quadrigasas, we've been involved on the claimant side, particularly, and this is one of the perhaps differences with here, particularly on the European cases, so the EU-wide cases where we haven't been involved in the investigation, but we get involved in the private litigation. Whereas in Spain, normally we are on the defendant side because we tend to be involved in the investigations in Spain.
I just wonder if I might make one comment. One comment in response to Bruno, and that's to make a distinction between cartel cases and abuse of dominance cases. A lot of the private enforcement, obviously, is where the Commission has established a trucks cartel or a refrigeration compressor cartel, and then people come in after the event with the benefit of the Commission's decision and they sue for damages. Nobody is going to go to court to try to prove that there's a trucks cartel. It's inconceivable. You need a public authority, dawn raids, years of investigation, etc. But I think abuse of dominance is quite different, because very often it's one player in a market with a highly focused complaint against Domco. There's no particular asymmetry of knowledge. We know what market we're in. I know how powerful you are, etc. My complaint is a specific refusal to deal or predatory pricing, etc. So that's much richer ground for private litigation, because you go to a competition authority with its prioritization principles. It can only do so many cases at a time. Something that's incredibly important to me in my business may not be that important to a competition authority. But if there is the possibility of bringing a standalone action in a court, then that might be the best answer. And I say this specifically because in the United Kingdom, with effect from October of 2015, our Competition Appeal Tribunal can now hear standalone actions. And there have been several examples already where a complainant has gone to the CAT, claimed abuse of dominance, and then we find within 6 months a settlement has been achieved and the case has gone away. Now, that seems to me in resource terms to be hugely important from the CMA's point of view, because something that they might in an ideal world want to have investigated, they can't. And then there's a court with a door open, a fast-track procedure, all sorts of rules on capping recoverable costs, etc., and it is already proving to be a very, very useful resource.
Just want to comment on that. As you think about developing your private enforcement regime, there are obviously some key questions that are going to affect how much you're going to be litigating and, you know, what the incentives are. Will you have treble damages? Will you have double damages? Will you only have single damages? Will the loser have to pay? That is a critical difference between the US and Europe. And the class action mechanism is the other. We call it the triumvirate in the US, you know, of nasties. The class action mechanism, treble damages, and the loser doesn't pay. That's fertile ground for private plaintiffs wherever the cartel occurs or the anti-competitive act occurs to try to bring that case in the US. The extent to which you'll be able to or interested in doing the same here in Brazil, I think will depend on the answers to those questions. You also asked about compliance. What impact does private litigation have on compliance? I can tell you that every time I go to clients with compliance training, the standard mantra is, and I'm not alone in this, that the government investigation is just the start. The real pain comes in the private action, which often results in, you know, billions of dollars more than the fine or penalty that you'll be paying to the government. And that is a huge disincentive for companies. It literally could break the company. So I think you'll find that to be effective as well. You know, one note there is that one of the clients I've represented for a while is a performing rights organization in the US. And their conduct throughout the ages has been defined and constrained as much by private litigation, much of it brought when the government declined to act, than by the DOJ. So, you know, that could be a ripe model, as Richard suggests, for Brazil, certainly in abusive dominance cases.
Carolina, temos uma pergunta.
Leonor, só minuto.
So just one very quick point, because it hasn't been mentioned yet, but it's an absolute driver in the European Union, and that's funding. What we've also seen in private enforcement has brought in this whole new reality of funding. So this is law firms who are working on contingency fees. It's insurance companies insuring against the risk of adverse costs, which can be very important in certain jurisdictions. It can be funds who are raising money to invest in litigation. And this is a key reality to take into account, and it's driving a lot of what you see in Europe. So what approach, if any, should be taken is something that has to be considered. Broadly in Europe, it's deregulated, or in some countries it's prohibited, but it's a big issue.
Obrigado.
Bom, a minha pergunta vai direcionada ao professor Kovacic, mas qualquer das pessoas que queiram responder, acho que vai completar bastante. Na ideia de casos de cartel e corrupção, no desenho institucional, acho que no primeiro painel foi falado bastante que a gente tem algumas autoridades que lidam com colaboração, leniência, e eu queria saber qual é a sua opinião sobre desenho institucional, se é mais interessante a gente ter um guichê único para receber tipo de colaboração nesses casos que envolvem tantos assuntos, ou se a concorrência entre as autoridades faz algum sentido para você ter incentivos a mais acordos ou até mais informações de diferentes pessoas que queiram colaborar.
I would say that we don't know the answer to that yet. We might have a better answer to that in about 10 years. I say that because the interesting policy developments have really begun to take root since, I would say, the early 2000s, where you see the more robust test of different institutional models. There are about 130 jurisdictions now that have laws. I'd say maybe a third of those can really bite you if you don't pay attention to them. A third of them never got off the flat line. There's some in the middle trying to work. As bewildering as it is to individual counselors who have to advise companies in dealing with this extraordinary mosaic, for researchers, there's an increasing basis for trying to answer your question, which is which framework works best. And we do see across the institutions that are operating, there's a remarkable degree of experimentation with Marianella, whose name I had on one of the slides. We've looked at all 130 jurisdictions according to basic institutional characteristics, and one question we focused on in particular was the degree of bundling or unbundling of functions. A growing number of jurisdictions are bundling prosecution, investigation into the same group in a ministry that would be called an executive ministry. They have to go to court to try their cases, but they achieve integration that greatly simplifies the treatment of these issues. The Department of Justice in the United States is a good example. Our first panel on Wednesday mentioned that. DOJ does not have to go to a separate prosecutor. It has to go one floor down in the building. We are the prosecutor. It doesn't have to go to a separate group of investigators. In a sense, it does. The Federal Bureau of Investigation is a subunit of the Department of Justice. And even within, just because you put things in the same house doesn't mean they work well together. And indeed, they do not always work well together. But you have a unification of authority that means you have no constitutional problems associated with sharing information, deciding who acts, and deciding in particular what the relationship between the civil and the criminal enforcement would be. And if you study the DOJ framework, they achieve a dramatic degree of simplification, because ordinarily, in thinking about the significance of leniency, punishment, you're talking to the one and only authority that will have the capacity to reach those decisions. It is an interesting complication when you go to our member states who have parallel authority and have their own laws that also in many instances allow criminal enforcement. I'm going to put that complication aside. But at the national level, that's a model of integration that dramatically simplifies all of the questions you have. If you have a civil law regime, you will have an inevitable amount of complication. There's no way to get around it if you have criminal enforcement, either in the competition law or in the anti-corruption regime. And the only solution there is a lot of conversations that ultimately lead to interagency agreements that clearly specify who does what and makes clear to outsiders what the sequencing of decision-making would be. But as I mentioned before, that takes a long time to develop because I think you can almost take it as a theorem. Take two public agencies, put them in the same policy domain in some respect, it is more likely than not that they will not work well together at the beginning. That is a slow growth over time. So I would say, and there's an obvious additional complication if you have the unification I mentioned. I said executive ministry. You have questions about autonomy and independence there because the chain of authority through the executive ministry in the case of the Department of Justice goes to the White House. The President of the United States could call the Attorney General or the head of the Antitrust Division or the Federal Bureau of Investigation and say, thank you for your loyal service. I want you out of there by 5 o'clock. No, make that by noon. I want you out of there. And the only appropriate response is, thank you very much, Mr. President, for the opportunity to serve you. It's been terrific. I'll be gone. So what you get with that integrated model often is a degree of potential direct political control that can make one nervous. Now, at DOJ, historically, there's a custom that said there's separation there. That's all up for grabs now. That's really hard to tell whether the custom will prevail. So it's possible almost as though you were going to purchase an automobile. And I can say this one has a bigger engine, it drives a lot faster, it uses a lot more petrol, and it's not really good for urban driving. This one has these other features. I think what we understand now better are the trade-offs, what each of these models does, what it takes to drive them effectively. But I think you inevitably face limitations with each one that require a lot of additional effort once you put it in place to solve. And the norm around the world today is administrative enforcement of the competition law. That's 80% of all jurisdictions, 80%. And many of them have decided to go criminal in some way on the continent, Chile, Brazil, Mexico. So if you take that step, you're going to be spending a lot of time building the bridges we talked about before.
Obrigada. Temos uma última pergunta, doutora Carla.
Bom dia a todos. Minha pergunta é especial aos representantes que atuam na dimensão da União Europeia, especialmente ao Dr. Paul, que falou ontem sobre os precedentes do caso Courage de Manfredi. Eu gostaria de ouvir se, após a diretiva sobre reparação de danos, como é que ele percebe a questão da margem nacional de apreciação ou se ainda há uma espécie de fórum shopping diante dos eventuais critérios de quantificação das indenizações.
Thank you very much. The answer is there's an enormous amount of forum shopping. So, I mean, you've touched on a very important issue in the European Union, which is the fact that you have 27 member states and each member state has a different procedural system. The differences are huge. They can really affect the way that a case is determined and how long it takes to get a decision. So there's a lot of forum shopping. Those rules are not determined by the directive, just to be clear about that. They're determined in regulations relating concretely the Brussels regulation in terms of jurisdiction. And so you can see people choosing certain national systems which they prefer. The preferences to date have been the UK, Holland and Germany. That's been driven in part by the funding that I described earlier. So that's an important issue. The directive doesn't enter into forum shopping and jurisdiction rules, but it does attempt to flatten the playing field. So it attempts to harmonise certain rules around Europe to try to make the differences not so noticeable and to try to encourage claims around the European Union. So it goes into things like limitation, joint several liability, and it also addresses key issues relating to quantification of harm, which will impact the way in which national courts deal with these issues. So presumptions of harm, disclosure is going to be coming into a lot of the civil systems. Maybe already, as a reaction to that, we're seeing with this famous trucks cartel case, it's the first European Commission decision where I think we're seeing claims in almost all the major European jurisdictions.
Bom, obrigada a todos. Em benefício do tempo, a gente vai passar para o próximo painel. A gente, infelizmente, vai cortar o coffee. E eu queria, mais uma vez, agradecer em meu nome, em nome do IBRAC, em nome do Ribas e do Léo, pela presença de todos e pelas excelentes contribuições, mais uma vez, do ponto de vista internacional. Obrigada.